Good morning. Thank you for coming. I want to give just a little bit more background on my professional history and my experience, because an important component of this debate is who do you believe? Who has the credentials, who has the background, who has the understanding of the Constitution of the United States to justify you accepting your position.
We have 200 years of case law from the Supreme Court that says the Constitution was written for the average person. If somebody tells you you have to be an attorney or a law professor or a judge to understand the Constitution, they're blowing smoke.
The rest of you from Virginia probably know that I was a Republican nominee for Lieutenant Governor of Virginia in 1993. I've been a faithful member of this party for a long, long time and have helped elect a lot of Republicans here in Virginia. And I'm proud to be a member of this party here in Virginia. Let's start off with this proposition. A lot of us think, and I'm sure Mr. Farris agrees with this statement, that the Constitution is not being obeyed by the government. The federal government just simply ignores the Constitution if you define the Constitution correctly. And defining the Constitution correctly is this: the Constitution as written and intended by the founders. That's the correct understanding of the Constitution. Now, however, there's a second Constitution, a de facto Constitution. And that is the Constitution as interpreted by the Supreme Court of the United States. The reality is the government does follow the Constitution, just the wrong one. It follows the Constitution as interpreted by the Supreme Court of the United States.
And let me say something real quickly here about this myth of the two constitutions. There's only one Constitution. And that Constitution is the one that the founders made. When they say that they're going to modify that Supreme Court, that myth Constitution, it's not going to be that myth Supreme Court Constitution they're changing the words on. It's going to be this one, the one that's in the National Archives, the founders.
Article 5 was given to us by a Virginian who didn't live very far from this spot right here, George Mason. George Mason is the person who said at the end of the Constitutional Convention, look at guys, this government's going to run away with power someday. And when it runs away with power, we have to have an ability for the states to be able to correct the abuses of power by the federal government. Congress will never propose an amendment to restrict or limit its own power. And that's the reality. Since the Bill of Rights, since the founding generation, if we start, the 11th Amendment, I guess we can count, but past the 11th Amendment, Congress has never proposed an amendment that restricts the power of Congress, ever. And if we think it's going to do so in this day and age, we are absolutely deluding ourselves. And any form of armed revolution, which includes nullification theories that basically say the state leaders need to pick up their guns and shoot the federal officials. That's a form of armed revolution. And that's the position advocated by my opponent today in the debates that he's done before. I've never debated him before, but I've looked at his materials online. And what we're experiencing today is the federalism atrophy that comes from the states never using their constitutional authority under Article 5 to restrict the power of the federal government. We see a runaway federal government that's absolutely drunk with power because the states will not, have not, and are being fear-mongered against using the actual Constitution itself.
You need to answer one simple question to decide whether or not an Article 5 is proper. All the rest of it is basically irrelevant. You need to answer this question for yourself. And the question is, why should we believe our public servants who have been violating the Constitution and their sacred oath for over 100 years suddenly start honoring the Constitution if we change the structure of the Constitution?